right, let's get started. Good morning, good afternoon, good evening. Thanks everyone for joining us today for our third installment of the Life Cycle of a Smart Idea series. Today's webinar is Patent Strategy, Optimizing Your Life Science Patents. Over the discussion today, we're going to highlight some of the issues that surround patent scope and the Doctrine of Equivalence. And as you will see, the doctrine is applied differently across different jurisdictions. And we'll offer you a few tips on how to maximize the doctrine in different jurisdictions. As a housekeeping matter, this seminar will be recorded and it will be available after the session is finished. We also encourage you to ask questions. You can just type it into the chat menu, and as the time comes at the end of the seminar, we will actually answer those. Next slide, please. My name is John Norman, and I'll be your moderator today. I'm co-lead of the Life Sciences Group at Gowling WLG. I have a PhD in biochemistry. I'm a patent litigator in Canada. And without further ado, I'd like to introduce our panelists for today. Our first panelist, Ruben Derzmakian. He's a patent attorney in Gowling WLG Moscow office, and he focuses on patent prosecution and litigation. Our next panelist is Paul Inman. Paul's no stranger, and Paul's been a partner with Gowling WLG in the London office for over 20 years. He has a degree in molecular biology and litigates intellectual property disputes in the UK and internationally. Our next panelist is Thomas Meyer. Thomas is a partner in Gowling WLG's Munich office with more than 20 years of experience in patent litigation, including a number of cases in life sciences. He's also been involved with a number of the key landmark German Federal Supreme Court cases. He's also a certified business mediator. Our next panelist, Dr. Zhang Zhu. Zhang has a PhD in biochemistry. He's duly qualified as a Chinese lawyer and a patent and trademark attorney. Zhang heads up our IP group in our Beijing office. And last but not least, Dr. Sonia Jishi. Sonia is a principal and patent agent. She heads up our Vancouver Life Sciences Group. And Sonia's focused on the prosecution of biotechnology and pharmaceutical inventions. So how this panel will work today is I'll pose a number of questions to our panelists, and our panelists will answer it based upon the information and the practice in their jurisdiction. But just to set the stage, what we're going to talk about is patent claim scope, and in particular, in respect of life sciences patents. And we'll talk about a number of the key strategies, how the doctrine of equivalence can be adopted in the various jurisdictions that we talk about. So as many of you know, when you review and understand a patent, the first place to go is to the claims, and you read the claims to get an understanding of what the invention is and what's covered. But the words of the claims themselves are not sufficient to understand the scope of the protection. So you have resort to the disclosure to understand the meaning and words of the claims. And that's how courts and the patent office construes the claims. They look at the disclosure, determine the breadth and scope of the claim. And as everyone here probably knows, that a purely literal reading of the claim is not the full answer to understanding claim scope. For example, a claim to a specific drug formulation would protect that specific formulation and nothing more. However, that's not how you're supposed to read a patent. And in fact, literal reading of patent claims allows people to design around and avoid infringement. Small trivial changes can be made that don't fall strictly within the words of the claim that would not be infringing. That's not how you're supposed to read a patent, and the doctrine of equivalence helps understand how the principle in many jurisdictions can allow one to include minor trivial variations that infringers come up with that don't affect the invention. So exactly what it is the court and the patent office looks for equivalence to the exact wording of the claim. For example, just a simple example, literal construction of a claim to a bike with a bell would not be infringed by a bike with a whistle. even if the purpose of the whistle was the same as the bell, namely to warn pedestrians that the bicyclist is approaching. However, the doctrine of equivalence allows for flexibility. It allows the patentee to catch infringers who try and avoid infringement by minor changes. It allows the words of the claim to be given life, breadth, and not strict reading. So how does this affect the life sciences? Well, there are two major things that have changed the doctrine of equivalence and why it has become more important in recent years. The first is an advance in technology. Infringers are developing new and interesting ways of trying to avoid patent infringement. And in my view, the second thing is increased regulatory flexibility. And as you will hear, right now, a lot of small molecules are facing a new type of challenge. In particular, there's a thing called salt switching. The innovator may have a patent for a compound with a specified salt. The generics will try and avoid that patent by coming up with a new salt, and regulatory flexibility has seen more and more generics switching salts to try and avoid patents. The other area where we're starting to see doctrine of equivalence play out a great deal is in the biological sphere. You tend to have a lot of antibodies, proteins that claim the protein that has particular action. Infringers try and avoid those claims by specifically changing a very immaterial minor amino acid and then alleging that the claim does not cover their variant because they've changed an immaterial minor amino acid. So that's an area where we're starting to see equivalence come into play. And with that background, setting the stage, I'd like to open it up and ask my panelists some questions and get their take on the doctrine of equivalence, claim scope throughout the world. So my first question is, what are the rules for the doctrine of equivalence in your country? And are there any rules specific to the life sciences sector? Thomas, let's start off with Germany.
Yes, thank you, John. I'm happy to do so. According to the basic rule on the scope of protection of a patent in Germany, which is for both German patents and European patents granted for Germany, the extent of protection conferred by a patent shall be determined by patent claims, but nevertheless, the description and the drawing shall be used to interpret the patent claims. This seems to be a general approach which is followed across many countries. The German Federal Supreme Court held in its famous Formstime decision, of Formstein is a molded curbstone, that the scope of protection of a patent generally encompasses equivalence to the patent as claimed. Another important milestone that should be mentioned was a set of 5 decisions rendered in 2003, which generated the so-called Schneidmesser questions. Schneidmesser is a cutting blade. These questions established a 3-step test in order to determine whether a patent is infringed under the doctrine of equivalence. The questions are, first, is the problem underlying the invention solved with modified means with objectively the same effect, which means the first requirement is about the same effect. The second question is the person skilled in the art able by means of his specialist knowledge to identify the modified means as having the same effect. So the second requirement is about obviousness. And the third question is, are the considerations to be applied by the person skilled in the art focused on the semantic content of the technical teaching protected in the patent claim, such that the skilled person takes into consideration the deviating embodiment with its modified means as an equivalent solution. So the third requirement is about parity. These questions have since then been applied by the German Federal Supreme Court. And the Federal Supreme Court has advanced and further developed its guidelines for the application of the doctrine of equivalence in numerous judgments over the years. As regards specific rules for the life science sector, it should be noted that these questions are generally applied in patents across all sectors, which means irrespective of whether a case is located in the sphere of life science or any other technical sphere. That's it from my side.
Thanks, Thomas. So Germany does have a long established principle for finding equivalence to be within the scope of a patent. Paul, what about the United Kingdom?
Yeah, thanks, John. So like Germany, we also have a doctrine of equivalence in the UK. But unlike Germany, I think the concept has had a very checkered history and has existed in various forms or not over the years. Start with the basic point. Patentees have been alleging that their patent should be treated as having a broad scope for years, well, decades probably, if not centuries. As long ago as 1904, in a case called Osram and Pope, the English Supreme Court was debating whether the alleged infringement was superficially different, but in substance the same. And even then, over 100 years ago, the Supreme Court was saying that this was a question of much difficulty. And that judgment ended up in a 3-2 finding in favor of the patentee. But it was towards the end of the 20th century, in the 60s and 70s, that the UK got its fairly established form of a doctrine of equivalence. It wasn't called that yet. The court would consider whether the alleged infringement took what they called the pith and marrow of the invention, effectively the clever bit of the invention, while trying to avoid the particular wording, the specific wording of the claims. And they called this as colorable evasion of patents. And they said that the pith and marrow approach to infringement was necessary to prevent such sharp practice, as they said. But it all changed in the UK in 1990 in the Improver and Remington case, which was in a number of European countries, when Lord Hoffman, as he was then in the Supreme Court, took the UK away from the most of the rest of Europe, basically saying there is no need for, and therefore there is no doctrine of equivalence in the UK. Now, Hoffman was a very literal person. He took a very literalist view, and he effectively said, look, it's the language of the claim that matters. Now, you have to interpret that language using the purpose of the inventor, but it's the language that matters. And it was this case, Improver and Remington, that he came up with what are called the 3 improver questions, which are how to interpret the claim, not how to determine whether something is equivalent, although these have gone on and I'll come back to them later. But basically he said the questions you ask are, does the variant, does the allegedly infringing item work in the same way as the invention? If it does, then you say, well, would it have been obvious at the priority date to the person skilled in the art that it worked in the same way? And again, if it was, you then ask yourself the question, nevertheless, does the language of the claims suggest strict compliance with the words? Now, that was UK purposive construction, but it went round in circles a little bit because it started with the wording of the claim and came back to it at the end. But that ended up being the case for about 30 years in the UK. Hoffman in that case found that there was no infringement, which was unlike most of the rest of Europe, where they found there was infringement. But just 3 years ago, this question went back to the Supreme Court, and from where Lord Hoffman was long gone, and Lord Neuberger said, no, Hoffman was wrong, there is a doctrine of equivalence. And effectively what he said was that variants that are outside the normal meaning of the claim can fall within its scope of protection. And he said, really, there are 2 questions to ask. Firstly, does this product fall within the normal meaning of the claims? Now, if so, there's regular infringement. But even if it doesn't, he said, you have to ask the question, does the variant nonetheless infringe because it varies from the invention in a way which is immaterial? And he said, if so, then it will fall within the scope of protection under the doctrine of equivalence. But what's different is that Lord Neuberger said you have to focus very much on the inventive concept of the patent. So is that material difference relevant to the inventive concept? So now in the UK, we have this very young doctrine of equivalence. And there have been so few cases that it is still developing. As far as specifically to life sciences, there have only been 2 or 3. So there's no clear pattern emerging from the life sciences point of view. And we're going to have to watch the judgments as they come out. But we very much have a doctrine of equivalence now in the UK.
Thanks, Paul. It's really interesting. Sonia, how has the doctrine of equivalence developed in Canada?
Hey, thanks, John. Yes, the doctrine of equivalence in Canada has actually a rich history that borrows heavily from the UK improver case that Paul just discussed. So in short, where the substituted element, such for example an ingredients or device, performs substantially the same function in substantially the same way to obtain the same result, then the element will be within the scope of a claim. So according to Canadian patent law, the first task of the courts in an infringement suit is to construe the claims. So the question basically that's asked during construction is, what does the claim mean? And purposely construction of the claim will show that some of the elements of the claimed invention are essential, while others are non-essential. So non-essential elements then can be substituted with equivalence within the claim, and it could still be infringed. So the Supreme Court of Canada found that it would be unfair to allow a patent monopoly to be breached by just a copycat device that simply basically switches bells and whistles to escape the literal claims of the patent. So therefore in Canada, the product or process that only differs from the patent by the non-essential element that I just discussed does not avoid infringement. So Paul mentioned earlier that the UK courts did not consider the improver question to be a doctrine of equivalence. However, here in Canada, the questions, the 3 improver questions, have been adopted by the Canadian courts as a basis for assessing whether the variant element in an accused product or process constitute an equivalent to what is claimed. I will not repeat the 3 questions, but it's basically the improver question that the Canadian court will ask. Interesting, so in the Free World Trust decision by the Supreme Court of Canada warned against using the doctrine of equivalence as it's borrowed from the US law in construing claim based on the spirit of the invention to expand the language of the claims. So the Canadian doctrine of equivalence only really exists as an infringement doctrine and considers whether the infringer has substituted or omitted an element that had been construed as being non-essential.
Thanks, Sonia. So it's interesting that Canada seems to borrow from the UK and in some ways dismisses the US.
Yeah.
Ruben, what about Russia?
Thank you, John. In the USSR, the doctrine of equivalence was used both for assessing patentability and in determining cases of infringement. In modern Russian law, the doctrine of equivalence can be applied in cases of infringement only. Until 2014, the time point to assess the equivalence is the time before infringement taking place. Since 2014, the equivalence is assessed before the invention's priority date. In general, under the new rules, it is less likely that something would be equivalent because equivalence is being assessed further in the past when the skilled person would have had more limited knowledge. Despite the absence of legal regulations or guidance, the courts to determine whether something is equivalent consider at least the following. The technical effect after replacement must be the same. An equivalent feature and a feature being replaced in a claim must belong to the same technical field. In terms of the life sciences sector specifically, the doctrine of equivalence is applied predominantly in the mechanical field in Russia, as is the case in China. It appears this is over the Russia takes a quite strict approach for assessing equivalence.
Thanks, Ruben. So interesting that it hasn't found its way into the life sciences as it has in the UK and in Germany. Sean, what about China?
Yeah, thanks, John. So comparably speaking, China is is heavily influenced by German practice. So as some of the audience might know, in 1985, experts from EPO, European Patent Office, come to China to help set up the China patent system. So ever since, China is very heavily guided by the European German practice. So I think all the principles that Thomas has outlined are also applicable here in China. So I won't repeat. However, so from a practical point of view, I will summarize 5 key scenarios where doctrine of equivalence can apply in China. So those are 5 key scenarios. So the first scenario is that a simple exchange of common technical elements. So that can apply to what John said, you exchange a sodium salt to maybe a different salt. So that's an exchange of common technical elements. The second scenario is a simple moving of the position of a product feature. So this mainly happens in the mechanical field. If you move some accessories a bit higher or a bit lower, that may be fall under doctrine of equivalence. So the third scenario is a simple breakdown or combination of technical features. So for example, for a bike, you might combine a whistle with the light, whether this can fall under doctrine of equivalence or not. So the fourth scenario is if you have a method claim, sometimes a simple change of steps in a method claim can also fall under doctrine of equivalence. And then lastly, this really applies to the numerical ranges. So simple or minor increase or decrease of quantity that can also apply with doctrine of equivalence. So that's the major 5 key scenarios in China for doctrine of equivalence. And lastly, I also want to point out that in China, the doctrine of equivalence can be limited by 2 other principles. So the first principle is so-called the donation principle. That is, you disclose an embodiment in the patent specification, but you don't claim it in the claims. So that is assumed to be donated to the public, and you cannot later protect those unclaimed technical solution or embodiments through doctrine of equivalence. Secondly, China also acknowledges the prosecution history estoppel. So what you said in the patent prosecution can be used against you. Yes, that's all for China.
Thanks, Sean. So let's look at question 2. Is there anything unique about the doctrine of equivalence in your country? Jean, let's start with China again.
Okay. Yeah. So for China, as I said, China is very much influenced by German and now US case law. So I wouldn't say unique, but I can highlight 3 trends. So overall, our observation is that China is much more stricter in applying doctrine of equivalence compared with other countries. That is mainly in 3 aspects. So firstly, about functional features. So many patent drafters, they like to use functional features because the language is broad. But in China, the court very much dislike functional features. And when it comes to interpretation of the scope of a functional feature, so very often you will find that the judges will interpret a functional feature to be equal or equivalent to the embodiments in the patent specification. So it basically becomes a doctrine of equivalence based on embodiments in terms of functional feature. So that is more limited than other countries. Secondly, I mentioned about numerical ranges. So in the past 5 years, the Chinese court, the trend, basically they will say doctrine of equivalence do not apply to numerical ranges. So what you have put down numbers in your claims, basically you are limited to the numbers that you put down. It's very hard to break through the numbers. And lastly, equally for in the life science, we sometimes use close-ended claims, which means we use language like a composition consisting of A, B, C. So if you use consisting of, which is a close-ended claim in China in the past 5 years, basically the court is very clear, doctrine of equivalence do not apply with close-ended claims.
Thanks, Sean. That's really interesting. So even though China has adopted the EPO and the German model, it still has a certain limit that you don't find in Germany. Thomas, along those lines, what can you say about Germany?
Thank you, John. Yeah, unlike Jian discussed for China, we have a specific defense against the allegation of an infringement under the Doctrine of Equivalence in Germany, the so-called Formstime defense, which the German Federal Supreme Court has developed in the decision which I mentioned before. First of all, I should emphasize that this defense only applies if infringement under the Doctrine of Equivalence is asserted, but not with respect to literal infringement. So what is this defense about? This defense brings considerations of validity and patentable subject matter into determining the scope of the claim. According to the Federal Supreme Court, the defense that the embodiment claimed to be an equivalent does not represent a patentable invention in view of the prior art is an admissible defense. This is due to the consideration that the scope of protection must not be extended to embodiments which are covered by the prior art. The defendant in a patent infringement litigation can therefore not only defend himself with the fact that the alleged infringing embodiment is known from the prior art, but also by the fact that it is obvious in view of the prior art. It is important to note that when this objection is raised, the German infringement court has to assess whether the embodiment said to be equivalent is indeed not patentable in light of the prior art. Accordingly, the Formstein defense is an exception to the principle of bifurcation, which is the rule that the German infringement courts usually do not have jurisdiction to assess the patentability.
Thanks, Thomas. That's interesting. So essentially what we've got now is a defense for infringement is the patent is invalid. So it's come both ways. Paul, how does that approach develop in the UK, and does it exist?
Yeah, so as I mentioned earlier, it's a new doctrine of equivalence. We don't have much case law, but the approach is fairly settled. First of all, you look at the normal interpretation. Then you ask if there is if the variant differs only immaterially. And as I said, this brings in the old three improver questions, but upgraded to new questions. And as I said, they're very much focused on the inventive concept of the patent. So the way the courts assess equivalence is to ask the following question. So the first one is, does the variant achieve substantially the same effect in substantially the same way? That's the same as the old improver question. But in this case, it's with respect to the inventive concept of the patent. So the court is having an eye to what is the inventive concept? Is the variant doing things in the same way as the inventive concept? The second question, as before, was, would it have been obvious to the skilled person that it would be doing it in the same way? But what's changed here is now the Supreme Court says you have to assess that at the time of the infringement. So it's interesting to hear that in Russia, they've gone the other way. As Ruben said, that equivalence is now assessed from the priority date. In the UK, we've gone the other way. It's worth pointing out that a number of judges have said that if you have a yes to question one, it's doing it substantially the same thing in substantially the same way. It will be unlikely that the skilled person doesn't know that. So questions 1 and 2 are tending to go together. If yes for both 1 and 2, nevertheless, would the skilled person think that strict compliance is essential, but again, with respect to the inventive concept? So the court is saying you've got to keep the inventive concept of the patent in mind. And in making the assessment, the court will, of course, consider the patent specification and the wording of the claims. But there is still a reluctance in the UK for the court to look at the prosecution history. Some judges may, some judges may not. But as a result of this, if the alleged infringement has differences from the patent, but differences which don't relate to the inventive concept, then the patent claims may reach significantly further than the literal drafting. But we really need more case law to see how far they'll go. It's just worth saying another unique aspect in the UK is we don't have any of these established defences yet. So as Thomas mentioned, the Formstime defence in Germany, where if something infringes under the doctrine of equivalence, if it was in the prior art, then you would have a defence in the UK, in Germany, but we don't have that defence yet. It's been talked about in a couple of cases, but it's not yet established. And similarly, we don't have the, if it's a selection patent and you mention a load of items, but then only claim one, you've deemed to have disclaimed the rest. Again, we don't have that yet. Again, these have been discussed in just a very recent case in Akebia and Fibrinogen just that came out last month. These were discussed, but they were sort of incorporated into the assessment of question 3. Would the skilled person think that strict compliance with the claims was required? So again, it's difficult to give any clear ways that the court is going. I suspect we may move towards Germany, but we need more case law at the moment.
It's really interesting, Paul. Thanks. So it sounds like you don't have a defense of the doctrine of equivalence, but that may be short-lived.
I think that's right, yeah.
Ruben, how about Russia?
As a rule, the evaluation of the technical effect which will be achieved by the product if one feature is replaced by another plays a key role in determining equivalence. If a replacing feature exhibits or gives a product a new technical property, it cannot be considered equivalent. In cases of infringement, there is a defense for an alleged infringer if they are able at first to indicate the documents from the prior art in which the equivalent feature is disclosed, and second, to show that the technical field in which the equivalent feature is disclosed does correspond to the technical field in which the patented invention belongs. So we have a defense in Russia which is a little like in Germany. It is enough to provide information about the design, functions, structure, and other characteristics of the found technical features, supporting the possibility of using such a feature as equivalent in a specific patented object.
Thanks, Ruben. Really interesting that Russia has fallen defense. Let's move on to question 3. So I'll ask the panelists to give an example of a case where the court found infringement by reliance upon the doctrine of equivalence. Paul, the UK has a very recent case, the Actavis case, dealing with this. I know it's also in Germany. So Paul, let's let you lead the discussion off for the UK. What happened in the UK?
Sure. Okay. So you're back to me pretty quickly there, John. Okay. Thanks. Right. Yeah. The Actavis case. So this was the case that brought the doctrine of equivalence into back into UK case law. So this was a case. I won't go into the facts too much, but the patent claimed effectively use of a sodium salt of the active ingredient. It was a pharmaceutical case. The question was whether the potassium salt, which was what the alleged infringer was using, was also within the scope of the patent. Now, with his new approach, Lord Neuberger said, right, well, the inventive concept of the patent was actually a combination of the anion of the active ingredient with another ingredient, which was vitamin B12. So he said the sodium moiety of that salt wasn't actually relevant to the inventive concept. It was just the drug part once it had disassociated from its salt. So he therefore held that a potassium salt fell within the claim scope because the skilled person would have known that the active ingredient would be doing the same thing in the same way, and it would have been obvious to any skilled person at the time of that infringement that that would have been the case. I think, as you said, John, Thomas will talk about this case a bit more because a different approach was taken in Germany, but that's a case where there's quite an extreme finding of infringement outside the literal scope the claim. And it's probably worth just mentioning one more case, again in the life sciences field. This was a case called Regen and E-Star. And the patent claim, again, boiling it down to the relevant bits, was to a process for preparing platelet-rich plasma. But part of the claim was you had to centrifuge whole blood in, amongst other things, a buffered sodium citrate solution at 0.10 molar sodium citrate. And the question was whether the allegedly infringing sodium citrate was at a molarity of 0.13, whether that was within the scope of protection. Now, I think before Actavis and Lilly, the specified claim integer of 0.10 would not have incorporated 0.13. It's plainly not the same thing. But importantly, in this case, the judge said that the doctrine of equivalence, our new doctrine of equivalence in the UK, applied equally to claims containing numerical limits. So again, unlike Ruben, who said I think in Russia that, or maybe it was Jan, sorry, I apologize, but that it won't extend to numerical limits. Here they said it would. The judge decided that the inventive concept was all to do with the centrifugation and dealing with the supernatant. And he said the evidence indicated that the molarity of the sodium citrate is not essential to the inventive concept, so would not have been regarded so by the skilled person. So in that case, they've been found that a claim to a specific molarity of 0.10 was found to cover 0.13. So that's where we are. I think there is, the UK is possibly a good place at the moment to enforce patents with numerical limitations if you're trying to enforce them against people outside those limitations.
Thanks, Paul. And, you know, I kind of, not that it matters much, but I kind of agree with the decision. A buffer of 0.1 versus a buffer of 0.13 is still doing the same thing. So,
but it's significant figures, John, 0.10.
I know we can debate this for a while. Thomas, as Paul mentioned, Germany has the Actavis case as well. How did it work out in that country?
Yeah, to start with, this Actavis case is called the Pemetrexed case in Germany. So we refer to this matter as the Pemetrexed case. And as Paul said, this dispute between Eli Lilly and Actavis concerned a European patent owned by Eli Lilly that is directed at the use of Pemetrexed disodium, which is the disodium salt of the antifolate Pemetrexed together with vitamin B12 for cancer treatment. And in the patent, apart from a general remark that all antifolates are suitable for use in the patented invention, the specification only refers to Pemetrexed disodium. The Actavis product comprised Pemetrexed dipotassium, which is the dipotassium salt, and also together with vitamin B12. First of all, and quite clearly, the German Federal Supreme Court found that there was no literal infringement by using the potassium salt instead of the disodium salt. The Federal Supreme Court then used this case to further develop its case law and to mitigate a quite strict approach they had taken in earlier decisions. For example, in a case of 2010, which we call Okklusionsvorrichtung, which is an occlusion device, the Federal Supreme Court had ruled that if an embodiment is only mentioned in the specification but not in the patent claim, the patent does not cover such embodiment. This is referred to as a selective invention. Essentially, if the patentee has considered and disclosed an equivalent feature in the specification, but they have not claimed it, they cannot later say that this equivalent feature should be within the scope of the claim. In the Pemetrexed case, the lower court, the appeal court in Düsseldorf, was of the opinion that by referring to a class of compounds, the antifolates, in the specification, all members of that class were detectable. So it was a selective invention case where the patentee had disclosed more in the specification than it had claimed. Therefore, the appeal court said that the potassium salt was not in the scope of the claim based on the doctrine of equivalence. In contrast to this, the Federal Supreme Court did not treat it as a selective invention and indicated that this principle is not to be applied in a case where a class of chemical compounds is concerned. By mentioning a class of chemical compounds in the specification, the patent does not automatically disclose all compounds that are members of this class. The reason is that the person skilled in the art usually needs additional information to individualize these compounds. Therefore, the Federal Supreme Court came to the conclusion that the disodium and the potassium salts should be considered to be equal in the sense of the third Schneidmesser question. The case was then referred back to the appeal court as the two other Schneidmesser questions still needed to be answered. The appeal court hadn't dealt with them, but had just focused on the third question.
Thanks, Thomas. We're getting a little short on time, so Sonia, I'm going to skip over the next section. Zhang, can you tell us about a life sciences case in China?
Yeah, so in the past 10 years, the most influential case in the life science is a Chinese Supreme Court case on the pain relief drug. And the issue is about whether the doctrine of equivalence applies with close-ended claims. So basically, the claim said the product consists of two ingredients. One is called adenosine disodium triphosphate, ADT. The other ingredient is called magnesium chloride. But the claim language is close-ended. The composition consists of ADT and MC. So the alleged infringing product not only have ADT and MC, they also have some accessories like sodium carbonate or arginine. So the patentee argued that those kind of accessories like sodium carbonate or arginine, they are not relevant to the inventive concept of the invention. So I assume in the UK now, that kind of argument will fly with the court, but not in China. So the Chinese court has 2 points. So firstly, the court said a close-ended claim is very clear that it only consists of the ingredients listed. So in view of the realistics, it might contain some impurities. That's understandable, but in this case, sodium carbonate and arginine are not impurities in the manufacturing. So secondly, the court is of the view that by using a close-ended claim, the patentee is very clear about the scope of protection, so the public trusts that. But now you are coming back claiming that the inventive concept is similar and disregard the language. So the court will disagree. So basically, the court don't want to apply doctrine of equivalence for close-ended claim, and the patentee is being punished by using that kind of claim.
Thanks, Zhang. So if I read this correctly, in the UK, we have a very broad organic reading of the claim, whereas in China, it's very strict, almost literal. And if you don't claim it, it may be a problem, right?
Yeah, it's mainly the close-ended part, which is a problem.
Let's move on to question 4. And I'm going to let Sonia lead the discussion on this and give us a fairly fulsome understanding. And so the 4th question that we have is, what is the impact of the doctrine of equivalence in your country, and how do you draft patent applications to either avoid the doctrine of equivalence or to capture it? Sonia, I'll hand it over to you.
Thanks, John. Yeah, and in terms of claim drafting, the objective is really to capture a competitor under direct infringement without really having to rely upon the doctrine of equivalence. And while the doctrine of equivalence can be used to capture a competitor during litigation, claims should really be concentrated on targeting direct infringement. And they should really encompass readily known equivalence. So there are several drafting techniques that can be used to cover the full scope of an invention. For example, if we have a claim that recites feature X and its equivalence. So to stay with the earlier example that John had, with a bell on a bike, if feature X is a classic thumb-activated bell, the drafter might also include an electric bell. So claims can also list feature X and all of the individual equivalents of X that the drafter could think of. So with the bell example, the drafter might want to expand the equivalence to other acoustic signaling devices, for example, whistles or horn. Then we also can include a multitude of claims, each individually citing feature X or the equivalence. And it's of course possible to include feature X described in generic language. For example, instead of reciting a bell on a bike, the drafter might want to recite a signaling device on a bike. And another option would be to use functional claim language. So the claim could recite a device for signaling or for making a sound, just, you know, to stay with the bell example. So while functional claim language is allowable under Canadian patent practice, it should be kept in mind that not all jurisdictions do allow it. And there's also risk of either claiming too broadly or including inoperable embodiments when using functional claim language. Another problem with these techniques that I mentioned is that they may broaden the claims both forward and backward. So for example, the claim might feature an electric bell for a bike, but then the drafter decides to use the broader terms of signaling device in an attempt to broaden the claim to also capture maybe electric horns. So however, now by reciting the signaling device, the claim is now so broad that some signaling device like a thumb operated bell, the classic bell, might also fall under this claim. So while the claim might capture equivalent technology, it also increases the odds that the claim literally encompasses prior art. So it really, when claim drafting, it requires a fine balance of drafting. So the invention is fully defined to provide maximum protection, but while at the same time, you have to avoid the prior art. Then, of course, there is also consideration with drafting the disclosure. So the claimed invention has to be enabled by the specification, and the claims need to be supported in the specification. So it can be sometimes difficult to balance enablement and support against claims that are broad enough to fully encompass the invention. So drafters should really consider first determining the desired claim scope, and then making every effort to make sure all disclosed alternatives in the specification literally infringe. The specification should also be drafted to capture subject matter that can easily be foreseen during application process. But as we discussed before, you keep in mind that under the specification dedication rule, subject matter that is disclosed in the specification but never claimed may be viewed as dedicated to the public. So therefore, if you choose to disclose the alternative in question, they should be really claimed as well. Disclosure dedication can be avoided by drafting broader independent claims, of course, and incorporating all disclosed alternatives in more narrow dependent claims. So these are kind of my takeaway and tips for drafting.
Thanks, Sonia. Zhang, how about prosecution tips for China?
Yeah, so my suggestion is prevention is better than cure. So doctrine of equivalence has to be considered as early as in the drafting stage. So I will offer 3 major tips about drafting China. So firstly, we are talking about claim 1, your independent claim. You should try to avoid any kind of limitation language in the claim 1. So what I say, for example, you should avoid phrases like at least, or not more than, or not less than, that kind of language. And also, if you have a method claim, you should consider maybe some steps are not sequenced one by one. So if so, you should avoid using a sequenced list in a method claim. For example, step 1, step 2, firstly, secondly, that kind of language, if the steps are not actually really critical one by one. And secondly, at the moment, China is very strict with numerical limitations and close-ended claim. So, especially in the life science sector, we use numerical ranges and close-ended claims sometimes. So you should try to avoid such close-ended claims or numerical ranges in your claim 1 as much as possible. Also, in the patent prosecution stage, when you reply to office action, you should try to avoid changing an open-ended claim to a closed-ended claim as well. So finally, as regard to the patent specification, you should have as many embodiments as you can, because many of the functional features in China will be interpreted as equivalent to the embodiments. And also, you should try to describe the working principle or the technical effect of any embodiments or any inventive concept in much detail. So later on in litigation, you have much more room to broaden your scope by doctrine of equivalence. So that's the 3 major tips I will offer from China perspective.
Thanks, Jan. That's really helpful. Ruben, how about Russia?
In Russia, some of the same considerations apply to specification and claim drafting, as Jan has discussed for China. In particular, you should try to avoid limitation languages in your independent claims to permit broad interpretation. The preamble of your independent claim should not be limited to technical fields or uses. To facilitate the application of the doctrine of equivalence, the working principle and technical effects of each embodiment and of the distinguishing technical feature should be described as much detail as possible, rather than skipped over or just touched upon.
Thanks, Ruben. Thomas, what drafting considerations would apply for Germany?
Yeah, quite briefly. The applicant should keep in mind that parity, you remember this is, parity is referred to by the third Schneidmesser question, that parity is denied in the case of a so-called selective invention. As I mentioned before, this means that certain embodiments are excluded from the scope of protection if they are disclosed or detectable in the specification but not included in the patent claim. Accordingly, if the specification discloses several embodiments of which only has been included in the claims, the scope of protection generally does not extend to the other non-included embodiments. Therefore, make sure that all embodiments for which you seek protection are actually included in the patent claim. To be on the safe side, do not mention other embodiments in the specification unless they are being claimed. However, as I also explained before, according to this recent Supreme Court case law, a claim directed at a specific chemical compound where the specification merely discloses the class of chemical compounds is not necessarily regarded as selective invention. This is due to the fact that the person skilled in the art would usually need further information to individualize the other members of the chemical class. Yeah, I think that's quite briefly about.
Thomas, Paul, in 1 minute or less, what would you recommend for drafting in the UK?
Sure. Well, it's easy. There's not a lot to say. I think the principle coming out of the UK court is that inventive concept of the patent is key. So if you get a broad inventive concept, even if your claims are narrow, you may well still find infringement by equivalence if the changes from the literal wording still deploy the inventive concept. So I think from a drafting point of view, try and keep your inventive concept wide. And then if you're limited in claim scope in prosecution, well, you may still have a chance.
Thanks, Paul. Thanks everyone for the presentations today. So just to sum this up very quickly, I guess the big takeaway message for me is if you can avoid the doctrine of equivalence, avoid it. Try and draft claims broadly, but avoiding the prior art so that you catch potential infringers. Although in the biologic space, we're seeing more and more chances where minor trivial changes can happen. So therefore, it's a good idea to try and draft broadly, but if you need to rely upon the doctrine of equivalence, try and focus on the immateriality of the change and focus on how the invention is still the same. Right now, I'd like to open it up for some questions. There's a chat function on the bottom. If you want to use that, if you have any questions, we can try and answer them. So please feel free to use the chat function for any questions you may have. Sorry, Q&A, my mistake. It's the Q&A button if you want to answer, if you want to put any questions in the Q&A button. While we're waiting for the questions to come in, I'm going to direct this towards Zhang, I guess. Why do you think the doctrine of equivalence has been so narrow in China?
Well, I think the principle is that I think China very much wants to balance between the public freedom and also the monopoly of patent conferred. So in the case I talk about this close-ended claim case, I think the argument is sound because the accessories are not really material, but because the patentee has used a close-ended claim, so that gives the public a trust that the close-ended claim means the boundaries are very clear. So if now the patentee comes back trying to argue that the whole inventive concept is similar, so that can actually diminish the public trust on the boundaries. So I think China is, as in many areas, can be more balanced towards a public freedom or public trust. And that's why I think China is trying to avoid people or patentee using doctrine of equivalence to broaden the scope on maybe more excessively in their view.
Thanks, Zhang. So we've got a question online. Paul mentioned that the UK courts may consider file wrapper estoppel in cases of the doctrine of equivalence. What countries actually do consider the file wrapper for assessing doctrine of equivalence? Let's start with China.
Yeah, so as I said in the beginning, China is actually very clear. So the court is very clear. Doctrine of equivalence should be limited by the prosecution history estoppel. So when the case is litigated in China, the prosecution history will be digged out and argued. So there is even a case in the life science, also by the close-ended claim. So the patent originally is open-ended claim, but in the prosecution stage, in order for the patent to allow to be granted, the patentee actually changed the claim from open-ended to close-ended. So that has a dramatic effect on whether doctrine of equivalence can be applied. So in summary, China is very clear. The prosecution history will affect doctrine of equivalence.
Ruben, how about Russia?
Actually, we have no legal rules or regulation establishes using a file wrapper. But actually, I know that in some times there are some cases where the file wrapper was applied, but it's not a general rule. It's not established by law.
Okay, thanks. That seems to be our time. Thanks everyone for attending today, and thank you panelists for agreeing to do this. Our next seminar is Global Patenting Strategies in the World of Tech and Engineering, and that is on June 24th. Also, this presentation was recorded and it will be found on the Gowling website, and we have a new platform called GoXL. So please feel free to peruse that and see what information you have. Thanks everyone. Have a good day, have a good evening, have a good afternoon.